Good morning to all the attendees of this event, or good afternoon or good evening, depending on your respective time zone. My name is Pietro Sirena. I serve as second vice president of the European Law Institute, and I am delighted to chair this webinar in which we are going to present the project carried out by the European Law Institute on enhancing child protection. It will be my pleasure to introduce first the two co-reporters that have worked on this project, namely Ilaria Pretelli and Susanne Gössel, to whom I would like to extend my deepest gratitude also on behalf of the Institute. And after their presentations and interventions, I will yield the floor to two external speakers who have kindly accepted our invitation to participate in this debate and to engage in the discussion of the project we are focused on, namely Elina Pekarinen and Alina Trifonidou. At the end of their intervention, we will have a Q&A session. Sorry, that is scheduled if we will succeed in keeping with the agenda, I believe that we will have at least 20 minutes, even more time to open the floor and to collect questions and interventions from the attendees. It's possible to use the Q&A function on the Zoom platform to post questions, and we will be delighted to take them and to ask the panelists to provide a reaction or an answer to your question, or also to comment on your intervention. With that said, I am honored to give the floor to Ilaria Pratelli and to Susanne Gössel. As I said, they are the somehow initiators and really the leading forces of the team that has drafted this project. Ilaria Pretelli is a senior fellow at the Swiss Institute of Comparative Law. At present, she is principal investigator of the International Just Bonding Research Project. As I said, she has served as reporter for the European Law Institute's Enhancing Child Protection Project, and she has also advised the European Commission on Parenthood recognition between member states. She is co-editor of the Yearbook of Private International Law. Susanne Gössel is director of the Institute for Private International Law and Comparative Law at the University of Bonn in Germany, of course. She is specialized on questions of private international law in the European Union with a focus on family law matters. She has served on the European Commission's expert group on the recognition of parenthood and on the Commission on Reproductive Self-Determination and Reproductive Medicine of the German Ministries of Health, Justice and Family. So I'm honored and pleased to yield the floor to Ilaria for her presentation, and then Ilaria is going to hand over to Susanne so that we will wrap up this first panel of our webinar. Please, Ilaria, over to you.
Thank you very much, Pietro, and I really would like to thank the whole ELI body for helping during this very interesting journey that led to the approval proposal that we are making with our excellent team. It is a very a crucial topic, a very essential and timely topic to deal with, and a very difficult one. So the European Commission was really brave and in putting out this proposal in what seems to be a far west of regulations, and so the proposal was really serves as a guide to make some clarity in the interest of citizens who now at present find themselves in a very difficult situation, because they get legal advice from private firms who navigate between the different legislations without an appropriate harmonized regulation. So the aim of this project was, once that we have, once the European Commission proposal was out, we also considered with Susanna and the whole team what might be the experienced difficulties of this proposal. Was I think mainly deal with a sort of ideological also aspect. And so the aim of our project, of the ELI project, is really to make a step backward and overcome the existing ideological division that make it difficult for the project to move on, and focus on the real problem and how we can deal with these real problems without making any ideological judgment, as I said, but just taking into account of the different stances and where they come from. And this, of course, I'm sorry, I'm a bit sick. This, of course, comes from mainly from the regulation of assisted reproductive techniques, especially when employing the gametes of donors and or resulting from legal or illegal surrogacy arrangements. So the challenge was big, and because of this, the irreconcilability of substantive law in this matter, even within the European Union, and this is, I believe, the reasons why it has proven difficult to promote a private international law instrument which would privilege a substantive regulation, the desirable substantive regulation of filiation over others. So by combining freedom of circulation and the right to continuity of status, it is indeed possible to ensure that what is perceived as the most progressive substantive regulation will ultimately prevail over the others. However, this result involves several what I may call collateral effects, because it means that we try to use private international law, as a colleague, an Italian colleague of mine, who used the expression as a Trojan horse to influence substantive laws of member states in a field which is an obstacle, which is in a field which is outside the scope of EU law. And so this caused quite a resistance, and in this respect, this is goes beyond the pure needs of coordination. Then the second effect is consists on a sort of limitation of the best interest of the child to continuity of status. And so these difficulties have led us to find ways and strategies to avoid getting dragged into this the political discourses by adopting what we call a gender an outcome neutral approach to private international law. And I would like here to insist on the fact that we are not proposing here the old idea that private international law is a neutral discipline. Of course, we are well aware that you can pursue substantive goals through private international law in both ways. That national laws, national private international laws can be shaped in order to promote substantive laws of member states and vice versa. But even though this is common in private international law, the only way to escape these difficulties here was to adopt a neutral, outcome neutral version of it by trying to prevent problems of coordination, the ones that we experience today. So this was one of the first approaches. We tried to focus on the practical problems, and the other specific plus addition of the project was to not only to limit the analysis of to get inspired in the private international law analysis by the LGBT strategy and the rights of the child strategy, but also to include women's perspective. So we invited all representatives from these three groups, although we also make it clear that children, we don't view children as a group, because it's all of us have been children. This concerns the whole humanity. It's not a minority, or it is, and as regards, but the representative of these three groups have led us to see and view the several dimensions of the problems of coordination experienced in cross-border filiation matters. And as one of the points that may be common to children and women's perspective is comes from the experience that we have with adoption, even though because in that context there were we have known about cases of substantial emotional or economic exploitation of adults seeking to have children, and coupled with the dangers of child and women's trafficking. So this, the addition of a women's perspective was very purposeful, and also the project extend the right of the child also to the right to know origins, and contains a specific article, Article 5, which affirms, which contains a strong statement on the right of the child and the need to respect the right of the child in the context of this procedure. So this is an overview of a synthesis, if I may say, of what we put forward in terms of what we clarified on private international law and children's rights, on the principle of non-discrimination of LGBTIQ parents, and the protection of women, in the fundamental premises that we added thanks to a request of the board to at the beginning of the project, and how we could reconcile all these different aspects. Technically, I would like to hand over the floor to Susanne, who will enter into the technical details. Thank you.
So thank you very much, Ilaria, for clarifying the theoretical mindset, which was our starting point. And now I will go through all the 152 pages of the report in the next 10 minutes. No, of course not. I will give you an overview about the main amendments we made. Our idea was not to totally rethink the Commission's proposal, but to improve it in little details, but to maintain the general idea and the main structure. So Ilaria already mentioned, very central for us was always to emphasize that the rights of the child and the best interest of the child is in our focus. And therefore, we further developed one paragraph of the original proposal, which gave the right of the child to be heard in a proceeding, and we extended it to a general right of the child, that the rights of the child have to be respected, and especially also the rights of the child to know the origins, to identity, etc. And then we followed the main structure, which after the general scope of application, etc., moves to jurisdiction. And here we're very much focused on what Ilaria also said already, on the best interest of the child in the sense of status continuity and status stability. And therefore, in our opinion, the several alternative jurisdiction grounds which were provided by the proposal were not feasible, especially if you combined it with the possibility to recognize decisions and always give priority to the second decision, because this allows kind of a forum shopping, to jump from one forum to the next to establish another filiation. And then this second decision would have prevalence over the first one. So this would mean an endless running after the fora and always creating uncertainty for the child, which filiation will at the end be the one which prevails. And therefore, we established a central jurisdiction ground, the habitual residence of the child, because the child is the person whose interest is most impacted. And then we left the forum necessitatis to have like an anchor forum. And then for the ascertainment of affiliation link, we also proposed an alternative jurisdiction ground, focusing again on the child who wants to ascertain the filiation. And then we have an alternative jurisdiction ground pre-birth situations. And there we have something which we also continue later, because in international filiation cases, we have always the problem, if we refer to the habitual residence of the child, that a newborn child or an unborn child has no habitual residence, at least in the case law established by the Court of Justice. And therefore, we continued the case law. We rethought the case law of the European Court of Justice, especially the Mercredi decision and the following ones, and therefore established kind of a new future habitual residence of the child in cases where a child has no habitual residence because it's not born or newborn. We look at the intended or prospective habitual residence of the child, thinking of the Mercredi decision, where you have to look especially at the intention of the principal caregivers of the child, or prospective caregivers. Then, regarding applicable law, we switched from the habitual residence of the person giving birth to the habitual residence of the child, again, to focus on the person which is the one whose rights are actually impacted. And here again, we have this possibility to go to the prospective habitual residence in case there is no habitual residence of the child because it's a newborn child. And then, as a subsidiary rule, as very typical in private international law in general, we went to the closest connection if we have no habitual residence and no possibility to establish a prospective one. And then finally, we have an additional one for determination or contestation of parenthood, that we can also go to the lex causa, which established the filiation link. And then we redrew the public policy exception in applicable law and also later in the recognition of decisions. Not because we wanted to change the content of the public policy exception, but because the Commission's proposal, the wording gave the impression that member states might apply an abstract application of the public policy exception. And those of you from private international law who are here know that the general approach to public policy is to look at the concrete result regarding the concrete relationship which is in question and not have a general policy observation. But to make it clear that this is what is supposed to be, we redrew the wording of the public policy exception to say we focus on the concrete application of the foreign law and the concrete result of this application. Regarding the recognition of decisions, I already mentioned that this rule that the second decision will always have prevalence for the first decision, which comes from child support decisions and the Brussels 2B regulation. We went back to the general rule that the first decision is the one which counts, to avoid that we create this instability for the child that she or he has always to expect another decision which will override everything. Then the proposal extended recognition to so-called authentic instruments with binding effect and introduced the categories of authentic instruments with binding effect and non-binding effect. And no one, I never met anyone in the whole decision who could exactly say what is meant with this. But the assumptions are that the binding effect means that it's an instrument which establishes parenthood. And we went in the group through all member states existent and didn't find any such an instrument which establishes parenthood. But the danger to have those different instruments, and in the second one, the non-binding one, focus on the evidentiary effects, in the first one not, creates the danger that the evidentiary effects of authentic instruments, which maybe are with binding effect, as no one knows what this means, would not have any rule for their evidentiary effects. So this will also create uncertainty and confusion. And so therefore, we propose to abolish the distinction and neglect the authentic instruments with binding effects as they don't exist, and only focus on the evidentiary effects, because in cross-border disputes, these are really the effects which count, and also establish a rule which law governs these evidentiary effects, which was something missing at the moment. And in the end, the proposal introduces a European Certificate of Parenthood. We changed that by name to filiation because we are child-focused, not parent-focused. And we added a value to this certificate. Ilaria already alluded to it. We want to introduce a certificate which fulfills certain minimum standards. And if these minimum standards are complied, then the recognition of the filiation link can be made easier. If not, member states can use the usual instruments. And to support everything, we propose to establish a central register, which also helps to connect the information about the child in the EU member states, and therefore also helps to support the right of the child to know the origins. So that's like a very quick wrap up. And now I'm looking forward to what other people make of it.
Thank you so much. We owe much gratitude indeed to Ilaria and Susanne for their presentation. But even more than that, we really this is an opportunity to express our gratitude and to say that we are much obliged to them as an institution. I'm now talking on behalf of the European Law Institute that I somehow represent here, for their dedication, for their work. They have so effectively led the research group that has worked on this project, and it has required a lot of time, a lot of efforts, and some to and through that are required along our procedures that we have in place because, of course, we are committed really to work on the improvement of the projects, on the quality of the products that we deliver, but also to reach a certain consensus, of course, of all the governing bodies of the institute on the works that we deliver. And as it was pointed out, maybe private international law may at first sight appear to be neutral and very abstract and technical per se, but then, as it happens for all the branches of law, this is more a result and an achievement that must be reached through work, through consensus, through discussion, as we are doing now in this webinar. And by the way, I reiterate the invitation to all the attendees of this webinar to use the Q&A function that is available at the bottom of your screen. There is an icon that you can use in order to activate this function. And by the way, I see that it's a pleasure and a fortune that we have to have our past president Pascal Pichonat attending this webinar, and so I would first like to greet him and to say that we are very happy that is with us today. And with no further ado, at this point, I would like to introduce to the audience the next two speakers who are going to offer us their views from different angles. First, Elina Pekkarinen is going to share with us some reflections from the viewpoint of an ombudsperson for children, because Elina Pekkarinen is the ombudsperson for children in Finland since 2019. And Elina Pekkarinen has a background that is rooted in academic research, particularly in the field of social work, youth and childhood studies. That has been also acknowledged by the University of Helsinki, where she is academically based. And among the many positions that she holds, I would like, or she has held, I would like to mention particularly the position of chair of the European Network of Ombudspersons for Children. And after Elina Pekkarinen's reflection on the project, on the ELI report, on the subject, we will hear from Alina Trifonidou some remarks from the perspective of EU free movement law, including the case law from the ECJ on cross-border recognition of parenthood and its implications for child protection. Elina Trifonidou is assistant professor of law at the University of Cyprus. And the research she conducts is focused, as I said, on EU free movement law and the protection of LGBTI plus rights under EU law. And she have, as a matter of fact, a very extended and interesting, I have to say, track record of publications that are concentrated, focused on this field and the policy debates at the EU level. And Alina Trifonidou has been a member of the Commission Expert Group on the Recognition of Parenthood between member states. And she has published a study for the European Parliament's Petty Commission on the Commission's proposal for a regulation on the cross-border recognition of parenthood. We have already heard that the project of the Institute of the European Law Institute we are discussing today is connected with this proposal of the European Commission that has basically provided, let's say, the starting point on which it has been further elaborated and built on further proposals by the research group guided by Ilaria and Susanne. With that said, I hand over to Elina Pekkarinen. Please, you have the floor.
Thank you so much, Mr. Sirena, and thank you, Ilaria and Susanne, for these very, very interesting presentations. I've done my best in listening, I've done my best in reading, but I must admit that as ombudspersons very often deal with the situations where the parents already are separating. And in these situations, too, the guardianship questions are really problematic and unfortunately very difficult to solve. I have done some desk research and asked around how often the issues of guardianship are met in the prior to birth or just after the birth. And these are, of course, not common, but we do meet them not frequently, but every time to time, and they are often very complicated. In Finland, in the past 10 years, the family structures have changed actually really rapidly. Until 2006, I think the most common family type in the whole Finland was a married couple with children. And today, only about 56% of families with children actually fall into this category. We have cohabiting couples, we have blended families, we have single parent families, we have foster families, rainbow families, and all these different forms of co-parenting arrangements, which are increasingly common. And these situations are way more complicated if the parents come from different countries or decide to move across borders. Well, as an ombudsman for children in Finland, I would like to highlight one of the report's key findings. Across Europe, a child's legal status can still change, and it can even weaken, simply because the family has different nationalities or decides to move across the border. And of course, this shouldn't be the situation. Our office, as I said, only occasionally deals with cases concerning the recognition of parenthood or legal guardianship outside these post-separation situations. So my engaging with this report was sometimes quite challenging and demanding, I must say, but it was also very insightful. So I really want to thank you. As I said, we have an increasing number of different family setups. And of these, I think legally very challenging are the arrangements where several adults share parenthood and all wish to be recognized as legal guardians of the child. And in these situations, sometimes one or several of these adults can be from another country. We have had situations where a family may include a married couple, while the biological adult or the parent is someone who is outside the marriage. And the Finnish law presumes that the husband is automatically the legal father and guardian of the child, and the recognition of the possible biological father may only take place after the child is born. And in these situations, it may arise both in the situations where the married couple is same-sex, in situations where the married couple is of different sex, gender, and also and different forms. It can also be that nobody is actually married, and after that it is, or prior to the birth, it is impossible to say who is actually the parent and the guardian. So these are really complicated situations, and I have no idea how these can be dealt with if some of the parents has a different nationality. Separation within these rainbow families can also involve particularly complex legal arrangements. And from my point of view as an ombudsperson, I think even though these are complicated cases, we have to always defend the right of the child to guardians, to parents, to family unity, etc. It is not the child's decision to have these different arrangements, and I don't think that they should affect their legal status, the child's legal status, and the right to have a parent and a family. Surrogacy, I think, was a really interesting thing. This is something we have discussed among ombudspersons as well. In Finland, or in Europe in general, I think this is an interesting paradox which you make here. The fact that surrogacy is prohibited, or at least very strictly limited, in most of the European countries. And the children that are born through surrogacy in outside Europe nevertheless return to Europe with their intended parents. Sometimes it happens that the visa runs out. The parents contact us because they are worried that they will have to leave the baby behind. And there's nothing I can do. There's nothing I can actually advise for them to do, because the arrangement, according to the Finnish law, is illegal. So all I can say is, well, you chose to go and you knew the risks. So now you just have to deal with them yourself. But when I think of this from the point of view of the born child, I think it is very problematic. And I understand that the national legislations seek to prevent surrogacy arrangements, but I mean, these are free people and they are able to access them in third countries where the practice is legal. And when they return to Europe and they ask their home state to recognize the legal parent, it can be causing a problem. And at least in Finland, we have difficulties not in giving the legal status to the mother, but for the father, it can be really complicated. And this creates a really difficult legal situation. On the one hand, the states wish to uphold their national prohibition of surrogacy. And on the other hand, they refuse to recognize the child's legal parenthoodship, and this may leave the child in a situation of total legal uncertainty. And this really, I think, raises serious concern from the perspectives of the child's rights. So I think this is a dilemma, and this is precisely one of the tensions that our European nations should have a debate on together. And I think that this report is a very, very good opportunity to address this issue together and discuss it as well. So I again want to thank ELI for organizing this and for publishing this report. Well, back to the surrogacy, the Finnish law does not allow it in any form, but we have families that go to third countries, and these are very painful situations for us ombudspersons too, because we cannot assist or even properly advise these families on how to proceed with the issues such as the registration of the child or questions of legal parenthood and custody. Also, there is one case I want to bring up, which I think actually underlines the importance of this report and how it is timely right now. And that is the anti-gender movement, global anti-gender movement, and its effects on child's rights in different family setups. I think this is an issue of equality, but also an issue of the right of a child to grow up free from psychological violence. I tell you one example. In Finland, we have seen increasingly active campaigns that are targeting sexual and gender minorities. And about a year ago in Finland, this citizens' law initiative, a law initiative made by citizens, actually advanced to the parliament. So it got over 50,000 supports. And the law initiative called for the concepts of mother and father to be returned to the legislation more explicitly. The history behind it was that in 2019, Act on Child Custody and our Finnish Paternity Act were changed so that the terminology used in these legislations was neutralized and harmonized in order to better reflect the diverse family situations. And I must say that the concepts of mother and father did not disappear. Rather, the language was adjusted to ensure the clarity and consistency in different family contexts. This citizens' initiative proceeded to the parliament. And because we have a certain type of government at the moment, the Legal Affairs Committee decided to organize a public hearing on the matter. And I participated. I was called there to work as to give my statement as an expert. Well, I consider the initiative unnecessary and emphasize that rather than focusing on the symbolic use of terms mother and father, what truly matters is precise legislation, the appropriateness of the language used in it, and the best interest of the child. The law has to meet the child's needs. But during the public hearing, I faced quite intense criticism, something that I also reported in, and it was also reported in the major national newspapers. I actually had to say to the spokesperson that I feel uncomfortable and I feel that I'm being bullied in this hearing, which is very rare. And in retrospect, I have seen that occasion as a rather worrying sign of a broader development in which the rights of children in diverse families, particularly the right to have their parents recognized regardless of their gender, is being questioned. So for these reasons, I find the report's recommendations particularly important and timely. Parenthood must be legally established, or a parenthood that is legally established in one membership state should in principle be recognized across Europe. I think this would strengthen legal certainty and, most importantly, prevent children from falling into situations where their legal status becomes unclear. And finally, I would like to emphasize a principle that runs, of course, through international law. In all matters concerning children, the best interest of the child must be the primary consideration. So when the European legal systems seek the solution of these cross-border questions, I think we should ask a very simple question. How can we ensure that the child's rights, identity, and family relationships remain protected, regardless of which European country the child lives in? I thank you for listening, and I look forward for all your good questions. Thank you.
Thank you so much. I hand over with no further ado because we are a bit behind schedule to Alina Trifonidou for her intervention. Please, you have the floor.
Great. Thank you very much, Pietro. Thank you to the European Law Institute for the invitation. It's really a great pleasure and an honor to be participating. And of course, to Ilaria and to Susanne for the excellent report. So obviously, I'm a free movement lawyer. So if I make any mistakes in relation to private international law, I ask for your forgiveness. So starting, I will be very quick with the first points I'm going to make. It's a lack of EU competence. This is in substantive family law. This is very clearly stated in the report. It's also very clearly stated by the Commission itself in its proposal. But the problem with this is that it creates divergence in national family laws, including as regards issues having to do with the child-parent relationship, In particular, surrogacy is specifically controversial, as we have said already, as the previous speakers have said, parenthood by same-sex couples, etc., etc. Now, this divergence in national family laws obviously creates the well-known problem of limping status that was already mentioned. And this is problematic because what it basically means is that we have a person moving from one member state to another, and a status that was legally validly established in one member state will not be recognized in another. So what this means is that we have loss of legal status, but also this has very important practical consequences. So the child and the parents as well will be unable to claim rights under EU law, which are dependent on proof of the existence of this legal relationship, but also they will be unable to claim rights under national law, which again, they're dependent on the existence of this relationship. Now, as a free movement lawyer, this problem of limping status is really problematic because obviously both the loss of the legal status as well as the loss of rights entitlements can obviously amount to obstacles to free movement. And this has been recognized already by the Court of Justice in its case law. So in particular, we have the VMA case, also known as Pancharevo, which was also confirmed subsequently in another case through order. In that case, we had a child that was born to two women who were married. Birth certificate was issued in Spain, where the family lived. And then one of the two mothers who had Bulgarian nationality asked her member state of nationality, Bulgaria, to issue an ID document for the child. But under Bulgarian law, in order for an ID document to be issued, there had to be also a new birth certificate issued for the child. So the question, well, the problem was that the Bulgarian authorities refused to issue a new birth certificate and refused to issue the ID documents for the child because they asked for information regarding who is the birth mother of the child, which would determine which one of the two mothers could be noted down in the Bulgarian document. The information wasn't provided, so they said, we are not going to issue anything. Now, what the court decided in this case was, well, a number of things that parenthood established in an EU member state must be recognized in every other member state for purposes having to do with EU free movement. So what this meant was that once we have a child-parent relationship established in a member state, then that can be relied on in any other member state to claim rights stemming from EU law. But this also meant, from the judgment, that this wasn't required when it came to rights stemming from national law, like maintenance, succession, and all these things. So that was an important case up to the point that it was going. So it didn't really resolve all the issues faced by families moving between member states and the problem of limping status. There is currently a case, I'm not going to go into it because I will not have the time for my comments on the report, which is what is important. But for those who don't know, maybe you want to take a note of it. It's currently a case pending before the EFTA court. It was submitted last November, and it concerns surrogacy, parenthood established in the US. The intended parents were a married same-sex couple. The parenthood established in the US was recognized, is recognized in Sweden, but Iceland is refusing to recognize it. So the argument is that this leads to obstacles to free movement within the EEA. Now, the proposed regulation is a great complement to the VMA judgment because it resolves the problem of the limitations of the judgment. As I said before, the judgment requires cross-border recognition for purposes when it comes to rights stemming from EU law, but obviously it leaves the child and the parents unprotected in situations where the parenthood, the proof of parenthood, is required for purposes of national law. Okay? So now about the report. I don't have any negative comments to make. So that will make obviously my speech a bit less interesting. But I have found very, very important the recommendation that was made regarding the geographical, if we can say this, the geographical scope of application of the proposal. So at the moment, the proposal is limited to requiring recognition of parenthood in situations where the child-parent relationship was established in an EU member state. But obviously, this leaves without protection any families where parenthood happened to have been established in a third state. So I completely agree with the proposal made in the report that this should be extended. I mean, the proposal should be extended to cover situations where the parent-child relationship was established in a third country. I make a parenthesis here in case I misunderstood anything. Obviously, please, you can correct me. Then the other thing I found very positive in the report was the emphasis on the child-centered approach. This is very important, and we can all agree that when it's the child that is the applicant, when it's the child that is presented that is the claimant and whose rights we want to protect and not, for instance, the parents, then obviously the case becomes much stronger. So I also believe that it's very important to present the proposal as a proposal which is indeed about the rights of the child. And the changes proposed with regard to terminology, the change in the connecting link that it should be the habitual residence of the child, and all these, I think these are really excellent. Related to this also is the emphasis on the right of the child, and also the fact, as was noted earlier, about how this should be balanced also with other rights in terms of women's rights, the rights of the parents, but of course, children's rights, the rights of the child are obviously the primary consideration. This, I think, is very important also because it takes into account the mainstreaming obligations let down in the Treaty on the Functioning of the European Union. So we have Article 8, we have Article 10, and the fact that women's rights should be taken into account in such situations involving parenthood and all these, and should be balanced with everything else, I think it's a very important point. Then the other very positive point as well is that the report proposes to focus on the child-parent relationship, so the relationship of the child with each parent, rather than the composition of the couple. I think that's an excellent idea, especially because obviously it will make again, it reflects the child-centered approach of the proposal as it should be. Plus, I think it will make the proposal more palatable to some member states. So again, that's an excellent point. And again, as noted in the report, something which I hadn't thought of before is that this will also enable the proposal, if it gets adopted, to accommodate in the future multi-parent situations, something which at the moment we don't really encounter much, but obviously maybe in a few years it will be something that will need to be taken into account. And the last point I wanted to make, and I finish here, is it's more of a question to the co-authors, obviously, of the report, which is about public policy. I'm referring here to the example with the co-mothers on pages 22 and 23 of the report. How do you see the public policy working, or what is your proposal in particular regarding the public policy? Susanne, I think mentioned already something about this, but if you want, if you are taking also questions from the panelists, then that is my question. Thank you very much.
Our thanks go to the last two speakers, Ms. Elina Pekarinen and Ms. Elina Trifonidou. Thank you very much for your valuable contributions to the discussion. And we, in principle, already have a couple of questions that Ilaria and Susanne might want to address, because both from the viewpoint of ombudsperson of a child and also in terms of public policy and other issues of private international law. We have already heard a number of interesting questions might be looked into and digged deeper maybe by Ilaria and Susanne if they want. And in the meanwhile, sorry, Ilaria, that I interrupted you, but just to reiterate the invitation to all the other attendees to put their question or to chime in with their intervention by using the Q&A function that is available at the bottom of the screen in the Zoom platform. Yes, please, Ilaria, I give you the floor.
Thank you very much. So the idea that about the proposal is really that we would like the whole of the member states to embrace the proposal. So the idea is that this proposal, we need harmonized rules of private international law for these cases, and we need it even more in states that are reluctant to adhere to this regulation. This is why I really like the word that you use, that it should appear more palatable because we are just focusing on the child relation with each parent. That was really the idea, because it's of course impossible to discriminate on gender orientation when you just focus on two persons relationship. One is a child and one is the adult. And as regards, so we tried to conceive rules that aim at preventing limping status, not only remedying through, which would be through the, for example, the neutralization of a public policy clause. We want to be realistic. We know that certain states will oppose public policy or will find stratagems to enforce their own law. And what we want to avoid is that the desire of having children through techniques that are prohibited will ultimately make these willing to be parents a prey of a combination of clinics and lawyers that will exploit their desire and make them believe that they can do this and there will be no consequences, and then they will find themselves in front of the ombudsman, who is without any instrument to protect them. So that this was I mean, we need to use also time. If states are not ready for certain result, we can give them time by saying at least we adhere on common rules that are that will reassure them that this is not a liberalization of the market and they are not deprived of their sovereign nationality. And so this was also the point of making it more palatable. As regards the public policy exception, this is, as Susanne pointed out also before, this is something that is to be evaluated by member states, of course, within the limits of fundamental rights. This is the European Court of Justice has already advocated many times that it can put limits to this evaluation. It has to be in line with non-discrimination, of course. So, but the project really adopts this very realistic approach. And we examine the real problem, the practical problem, and the feasible solutions. To make it be adoptable by states who, as to now, are fiercely reluctant to any instruments of private international law. But yeah, that's to make them understand private international law may be efficiently used to coordinate, and we need coordination at this present moment. Susanne?
Yeah, thank you. You basically said the main points. I might also add what you said briefly. If we have a concrete control of the result of the application of the foreign law, we also have to, we see a development on the European level that the European Court of Justice is kind of streamlining the case law with the case law of the European Court of Human Rights, as we can see in Mirin and what's it called, Torian. This will obviously also come into the public policy exception in other instruments. And regarding, for example, surrogacy, the European Court of Human Rights also has a long row of case law that the rights of the child and the relationship to certain filiation links has to be recognized or can only be refused in very exceptional cases. So this will also go into the public policy exception, even in states which are very reluctant to accept family relationships they don't know.
Thank you very much. I see a couple of questions that have been posed in the meanwhile that have popped in the Q&A box. I think we have time available, so I would be delighted at least to pick up all that we basically will be able to take on board. I will start with a question from Eleni Zervojani. And she, if I may summarize her point, she focuses on the intended habitual residence of the child as connecting factor that has been opted for in the framework of the ELI project. And Eleni Zervojani raises some concern about this choice of this connecting factor is really, say, most suited to pursue the best interest of the child, because she points out that the intended parents will be most likely from a country that prohibits surrogacy. And therefore, the establishment of parenthood on the basis of the law of that country, the country of their habitual residence, could delay the establishment of parenthood. Maybe they would need to run a procedure of adoption, special cases, if they are impeded from being recognized, established as parents directly. And then Eleni Zervojani also expresses some concern about the possibility that there are some changes in between. As an instance, what happens if one of the parties die, or if the intended parents divorce or separate in the meanwhile, and no adoption takes place. And she also points out that this would not, if I understand her point correctly, this is not an issue, say, according to the EU proposal. So this problem would not arise, and therefore she wonders whether this changes suggested by the ELI project would not amount into some difficulty that is somehow introduced by this shift of choice with regard to the connecting factor. Ilaria and Susanne, do you want to take this or yeah?
I can take it. Thank you. Well, first of all, I would like to emphasize again what Ilaria said at the beginning. We have the approach that we are not meddling with substantive law. So we are not going into to judge a legal system, how they see surrogacy, or how they want to deal with certain cases. That's something of substantive law. The European Union doesn't have the competence in family law matters. We only look at the coordination, and regarding this coordination, we look at the substantive values which are behind everything from the private international law perspective. So we zoom out. But looking at surrogacy, we kind of have the situation in Germany, because we have our central connecting factor as the habitual residence of the child, and then we have some alternative connecting factors which usually do not lead to an additional legal system if the intended parents are from Germany. But what we can see at the moment is that the intended parents do no longer rely on conflict of laws. What they do is they go, for example, to Ukraine, get a surrogacy, and then they go to a local court and get a confirmative judgment that parenthood has been established. And then they go to Germany and say, we want this judgment to be recognized. So the conflict of laws track is not very important in questions of surrogacy. Usually the recognition of court decisions is the one which will be used because it allows a simpler recognition. You don't need to go by acceptance. And then it all falls down on public policy. And that's the only thing where member states have the possibility to decide in one or the other direction. And that's also I think that already answers the question mainly. We did not think we should create a conflict of laws rule as the proposal kind of does, which is focused on the problem of surrogacy, solving it by an applicable law norm, because the habitual residence of the person giving birth is exactly made for the case that the surrogate mother has the habitual residence in another country, and then this law is applicable and leads to the acceptance of a surrogacy obtained abroad. And we thought we should make an instrument which is made for all legal situations, especially for families who are also established in the traditional way in other ways. And we should make an instrument which is feasible for all of them. And we did not regard the case of surrogacy and applicable law as so relevant. As I said, the development in Germany, and I think also in other jurisdictions, shows that applicable law and surrogacy is not really the problem. Public policy is, and that's why we were very specific about the public policy exception. I hope this answers the question.
Thank you, Susanne. I don't know whether Ilaria wants to add something or...
I could add something maybe with the next questions, because I see there's another one.
Yes, there is. Yeah, there are several ones, but at least I would pick up one. Then we will see. Sorry. I'm also a bit sick, so sorry for that. But Brooke Marshall from the University of Oxford, and one point that we find here in this intervention is about the third states, the countries not belonging to the EU. And this invites us to reflect and to elaborate on whether the proposal, the project from the European Law Institute can provide further inputs for reflections, or also for ignite reform discussions, and of course on the issues that are of our concern in third countries, in countries not belonging to the European Union. And I see that Ilaria is going to take this.
Yeah, thank you. So yes, I would answer yes. It's the 10th fundamental premise that we make is really that we did think about this project with a view of proposing amendments to the European Commission proposal, but it is adaptable, especially as regards the jurisdiction rules, applicable law, and authentic acts. I mean, it is completely adaptable to more broader contexts. So for an international convention, for instance, but also for the drafting of national private international law rules in the case B. And as regards if I may add a little bit on the previous question, I would just add that it is very controversial now what is the best interest of the child, and how especially to assess the best interest of the child in context of surrogacy arrangements. Of course, continuity of status, this is essential for many reasons, but but the Commission also mentions the right of the child to be heard if the child, of course, is capable of forming their views. But there is also the right to identity also encompasses the right to origins, and not all legal systems that have legal rules on surrogacy arrangements, they have rules that allow that may through which the child will enjoy this right to know origins, which is very important. In every time I have meetings with donor-conceived persons, they really strongly advocate for this right to be respected, because they don't want to find themselves with 100 siblings, or this is a market completely unregulated. And so it's also, the project has a policy of nudging in a way, so a photograph of what are the real problems now and how we can coordinate within these different views. But there is also a part on nudging, which says in order to get a European certificate of filiation, which should be contained in a uniform European, in a centralized European register, not in a coordination of national ones, but in a centralized European register. Certainly, the right to identity and no origin needs to be respected. There are several mechanisms to do so. This is not impossible, but it's a way to facilitate filiations that are whose background is more respectful for the future child and the future person who will have to deal with these origins. I don't know if I answered. Yeah.
Thank you, Ilaria. And Susanna, have seen her hand raised, so maybe she wanted to add something, please.
Yes, I would like to add something to Brooke's question. We thought about the third state cases, and there is always the big question mark regarding the so-called acceptance by conflict of laws or recognition by concept of conflict of laws. And you might remember in the Rome III regulation, which deals with divorce, the European Court of Justice said that you cannot apply the Rome III regulation as an instrument to recognize or accept a divorce obtained in a third state, which is not recognizable as a judgment. And we thought about how this would play out regarding the Parenthood proposal, and therefore we introduced a recital which said member states are allowed to use the conflict of laws rule to provide this kind of exception to third state cases, but they are not forced to if they have another mean which is more favorable towards a child to accept the parenthood. Because I also did a study some years ago about the instruments to accept the status in the EU, and there are several member states which has easier mechanisms than the acceptance by conflict of laws, and we did not want to prevent those member states to use those instruments if they favor the continuity of status of a child. So we thought about it, and we introduced this little remark that there is a possibility to use the proposal.
That's very interesting. Thank you, Susanna. And before taking a further, I'm afraid, the last question, because I see that we are approaching the time to wrap up. But first, I wanted to say that I have turned directly to Ilaria Pretelli and to Susanna Gössel because, of course, they have authored that project we are discussing today. They have led the research team that has drafted this project. But of course, we are most interested and happy to hear also from the other two speakers. So today, Elina Pekarinen and Elina Trifonidou, if you wish to contribute to the discussion that has been so far developed, of course, I would be delighted to hand over to you. Otherwise, we can, as I said, take a last question. And I'm happy to say that it's a question that has been posed by somehow a representative of organizations working directly with migrant families. And I think that is extremely helpful and really meaningful that we can also include such organizations in our discussion of today. And it's Lydia Kanai who put this question that invites us to reflect on migrant families and the delays they are confronted with in recognizing parenthood across member states, and this, of course, results in major legal uncertainties about the status of the children. And Lydia Kanai invites us to engage in a further reflection on the mechanisms that could be adopted in order to mitigate these legal uncertainties and to find out mechanisms to alleviate and to redress possibly this administrative limbo or this legal limbo in which these children and their parents, of course, find themselves. So this, I guess, it's addressed to any of the speakers of today. So it's not only focused on the project per se, but it can, I mean, raise a larger discussion and also stimulate several contributions and interventions to whom I might give the floor of the speakers.
I gladly take the floor, but I saw Elena, maybe she wanted to add something. Did I guess it right?
Thank you so much, Ilaria. It was nothing that important. I just think that the question about the surrogacy and how we and the question of the country of the birth is really relevant, I think. And I know that among the ombudspersons, there have been inquiries of how different countries deal with the surrogacy. So I know that this is a subject that is becoming more and more relevant all the time. In ENOC, the European Network of Ombudspersons for Children, the members are not only from EU countries, 22 are, but we have 44 members altogether, 43. And of those, majority come outside European Union from the Council of Europe countries. So these are issues that we share, and that is why I think that the question of which of the issues can be discussed with the third countries is so relevant, because they are not like third countries that are far away in the States or in the South America. They are countries like Macedonia, Ukraine, etc., that are very close by and with which we collaborate all the time. So I think these are very relevant questions. Thank you. I don't have the answers though.
Thank you so much. Over to Ilaria again.
Thank you. So since the project avoids selecting cases from EU, intra-EU cases and extra-EU cases, this should be facilitated. And to answer the question on the legal limbo, of course, this is something we want to avoid. And this is also the reason why we imagine the two-track system for recognition, a fast-track system for children who, and in case, to obtain a European certificate of filiation, which would be immediately be retrievable in all member states, and so would attest as to the legal status of the child, provided that the parents and all those involved in the birth have respect certain basic rights of the child, which we identify in this Article 5, proposed new Article 5 of the project. As regards all others, they would go through the normal channel of national channels of recognition and then be subject to the scrutiny of a member state, as it happens today, and that can cause delays. But sometimes these delays may be in the interest of the child, in the sense that if there is a suspicious situation, let's say, the authorities must be able to do their work and protect the child with the means that required. Of course, in all this, there is a perspective of it is very training, and it's very important, because we want to avoid, of course, that prejudices or other cultural obstacles may come into the way and hinder a multicultural dialogue which is in favor of the child and that child's family.
Thank you, Ilaria. I believe we are about to conclude this webinar, so let me express my sincere gratitude, first of all, to the 4 speakers. We had really the privilege to hear today first the co-reporters of the ILI project on enhancing child protection, namely Ilaria Pretelli and Susanna Gössel. So first and foremost, kudos to all for all the work that you have conducted, also in the interest and on behalf of the Institute. So we are really obliged to you, and many thanks to Elina Pekkarinen for having offered their views from the side of ombudsperson for the children, and Alina Trifonidou for having enriched the debate, particularly from the perspective of freedom of movement inside the EU. And of course, to all the attendees, particularly to the attendees who chimed in with their intervention and questions. We have been really delighted to see so many interests sparkled by this webinar, and I allow myself to encourage you to have access to the project that is now disseminated and publicly available. And of course, we will be more than happy to receive more inputs, more observations, more criticism. Why not? That it's always useful to prompt further reflections and really to provide the improvement of the products and the research projects of the European Law Institute. And last but not least, of course, thanks to the Secretariat of the European Law Institute to put up all the, technical surroundings of these webinars and provided their assistance and help to run this webinar smoothly. So thank you again and goodbye. And of course, I hope to see you soon in the next webinar of the European Law Institute.